Welcome everyone to the AALAS webinar, Legal Issues for Small Nonprofit Organizations. My name is Sally Westlake and I'm the Director of Professional Services at AALAS, and I will be serving as moderator today. Our speaker today is Jim Flood. Jim holds a Bachelor's of Arts from Carthage College, a Master's in Education Administration from Roosevelt University, and a Juris Doctorate from DePaul University Law School. Jim joined AALAS as our legal counsel August of 2015. Welcome everyone, and let's begin.
Thank you, Sally. I want to express my appreciation to everyone who's participating in this webinar today. As Sally said, my name is Jim Flood. I'm the AALAS legal counsel. I've been here 10 months, and just so everyone knows, I'm still learning much about this organization and its branches. So if I have some inconsistencies in what I say today, I apologize up front. Previously, I served as Ducks Unlimited's General Counsel, Assistant Secretary, and Risk Manager for 23 years. Ducks Unlimited is a 501c3 nonprofit corporation with approximately 3,600 chapters across the United States involved in fundraising. In addition to being an employee of Ducks Unlimited, I was also a volunteer and area chairman for one of our local committees here in the Memphis area. The reason I bring this up is to let you know that I have some nonprofit experience, and many of the examples I will use today will come from my Ducks Unlimited experience and not from my AALAS experience, because, to be real honest, I don't have a whole lot of AALAS experience yet, but I'm getting some as we move on. Today, the topics we'll cover today will be about the branch, officers and directors' duties, corporate responsibilities, the IRS 501c3 nonprofit status, the IRS Form 990, which is a form that has to be filed annually by 501c3s. We'll have a little discussion on the mission statement of an organization, discuss insurance and risk management, and bring up some financial protection issues that come from Ducks Unlimited, but with all our volunteer committees. And then we'll have a period for questions. Let's start with the branch. A branch is defined in the AALAS policy manual as a group of individual national members and others in a local area dedicated to supporting the mission and philosophy of the association, and which desire to use the name American Association for Laboratory Animal Science in its own organizational title. To be a branch, you are required to have at least 10 national members, so you should need to remember that as we move forward. When you become a branch, it's a membership status, and you get certain benefits for this membership status. One is access and participation in the branch listserv, and I would recommend your participation in this. It's a good way to share ideas on how to make your branches more successful. Also, the AALAS national leadership is available to participate at your branch meetings when requested. AALAS National will offer leadership training, webinars like we have today, seminars at the national meeting. One that I should note is on Monday afternoon at the national meeting this year. There will be a session on meeting planning for branches, and there's also the Leadership Academy. Your membership right also gives you the right to use the AALAS name, American Association for Laboratory Animal Science, the AALAS initials, AALAS, and the logo. We have a branch manual that's available. It is being updated currently. At the last board meeting, which was last weekend, the board of AALAS approved a new revised policy manual for the organization. It didn't change many policies. We just updated the language so it read more like a policy manual. We are in the process of updating the branch manual, and that will be available soon. You have your branch name and web address posted on the AALAS website. There's an information and support resource person here at National. Her name is Carolyn Campbell. Her email address is shown on the screen and will be in the package you receive. You have the right to use the AALAS mailing list for a fee, and there's the Ben Cohen Branch Education Fund, which is used to pay partial expenses for speakers at your branch. A couple things. Branches are independent entities. They are not part of AALAS National, other than as a membership organization. National AALAS bears no legal responsibility nor accepts liability for the actions of a member branch. The member branch doesn't share the national AALAS's tax-exempt status or other legal statuses of the organization. And AALAS does not provide financial support to member branches other than the Ben Cohen Education Fund. We're going to talk for the next several minutes about legal duties of officers and directors of a corporation, including nonprofit corporations. These are duties imposed by law on organizations and their officers. At the end, we're going to talk about some protections, too, that are imposed that you get if you follow these duties. The directors are subject to two duties. It's a duty of care and a duty of loyalty. It's a legal obligation for a director on a board to act within the scope of these two duties. And I would suggest that it's wise for anyone in any organization, whether incorporated or not, to act within these duties. The duty of care is the first one we'll talk about. The duty of care requires an officer or a director to participate in the decisions of the board. What is participate in the decisions of the board meeting? This means you have to show up. You cannot exercise your duties of a director unless you're at the board meetings. The board of directors acts as a whole unit and not as individuals. So the first thing you need to do is show up, whether it's for your board meetings. The next is to be informed of data that's relevant to the decisions that are going to be undertaken by the board. You need to know your mission statement for your branch. You need to have some familiar with what your bylaws require. You also need to be familiar and have studied the information that's going to be presented at your board meeting. What's the purpose of the meeting? It's incumbent on the branch leaders to make sure that all this information is distributed to its board members or directors in a timely manner before the meeting, so there is an opportunity for the board member to review the information and be prepared for the meeting. And the last duty of care is to act in good faith and with care of an ordinary prudent person in similar circumstances. This means to be aware of what's coming up at the board meeting, to study your materials and act accordingly. You don't have to be an expert. There's no requirement that you're an expert on everything that will be presented at a meeting, but if you have questions, you have the obligation to ask and get answers to those questions. The decisions you make set the tone and direction for your organization. The second duty is the duty of loyalty, and I think this is very, very important. It sets the tone of the organization and the public perception. The duty of loyalty requires a director to exercise their powers in the interest of the branch and not in their own interest or in the interest of another person or entity. The duty of loyalty primarily relates to three things: conflicts of interest, which we're going to discuss a little further in a second; corporate opportunity, which is when you are a board member and you learn something your organization wants to do and you try to do that yourself, so you get the opportunity and financial reward for taking that away from the organization. And then there's confidentiality. Certain things are said at board meetings that aren't for public display or dissertation. So remember that. Corporate opportunity is an example. When I was at Ducks Unlimited, any acquisition of property had to have board approval. And if a board of directors person would have heard about this great piece of property and then went out and bought it himself, that would be a violation of the corporate opportunity clause. Let's talk about the conflict of interest and conflict of interest policies. A conflict of interest policy is a policy of disclosure. It's not a prohibition. You are all very active people and have lots of interest in businesses and family and all kinds of interests. There's a large chance that there will be a conflict of interest between your duties to AALAS at some point and your duties to your employer or to your family or someone else. There's nothing wrong or illegal about having a conflict of interest. They happen all the time. They're perfectly acceptable. What is the issue here is how the director and the board deal with a potential conflict of interest determines the propriety of the transaction. A director must be aware of if and when his interests or her interests or those of the immediate family or any part or group or organization which they have an allegiance may be seen, and may is a key word here, may be seen as competing with the interests and concerns of their branch. When a director feels there may be a conflict of interest between his personal interests and those of the branch in some manner that he's dealing with the branch on, he must disclose those issues to the board or the relevant committee where the conflict comes from. The determination of whether there's a conflict of interest isn't made by the person director saying, I have a conflict of interest. It's made by a disinterested majority of the board or committee. But you as the director must disclose when you think there may be a conflict of interest. This is very important. If you disclose there may be a possibility of a conflict of interest, other than to state that you think it is and why, you do not participate or make in the decision-making process or make the decision. If it's determined that a conflict does exist by the board, the director must be excused from the room and retire from the room and not participate in any further deliberations or decisions regarding the matter under consideration. AALAS National has a conflict of interest policy. The next several slides will show a copy of that. If your branch doesn't have a conflict of interest policy, I would recommend that you review the AALAS policy and see if it will fit with your organization. Again, it tracks what we've just talked about. It says anyone in an elective, appointed, or employed office or position does so as a representative or fiduciary capacity that requires loyalty to the association. At all times, an individual shall further the interests of the association as a whole, and shall avoid placing them in a position in which their personal or professional interests may conflict with the duties of the association. Using information learned through such office or position for personal gain or advantage, that's the corporate opportunity again, or obtaining from a third party improper gain or advantage. And we also talk about nominees and candidates that they have to agree to comply with this conflict of interest policy. And an individual who serves an elective, appointed, or employed position shall disclose any situation which might be construed as placing the individual in a position of having an interest that may conflict with his or her duties to the association. Like I said, there's nothing wrong with having an interest that conflicts with your duties to the association. The issue becomes when you don't disclose them so the association can act accordingly. And this is just the end that says that people will follow the policy. We've talked about some obligations. Now we'll talk about a legal protection that you have as a director. The business judgment rule is a legal standard which provides legal protections from liability arising from a director's corporate decisions, even if the decisions are proven after the fact to be unwise or unsuccessful. You want to buy something as an organization and the company doesn't pan out afterwards. This is more really for-profit corporations, but it applies to nonprofits as well. And you have this protection as long as you acted in good faith, going back to our duty of care and duty of loyalty, in a manner reasonably believed to be in the organization's best interest, and with an independent and informed judgment. The business judgment rule will not protect a director from liability if they fail to disclose a conflict of interest. And you as a director expose yourself and the board to substantial risks if you fail to disclose a potential conflict of interest. A number of years ago, Canon cameras had an advertising slogan which said, "Image is everything." I think it was used with Andrew Agassi, who was a professional tennis player at the time. And they had some point there. It's not true, but how you act as a director and leader of an organization and what you do reflects to people what the organization is about. Now, I was told when I did this in rehearsal that I should let you know that this has nothing to do with any specific activity that any branch or AALAS National has done yet. This is coming from Ducks Unlimited. But when you do something, you are, as the leader of your branch or as a person under the name of AALAS, you are setting the tone for those people that see you do that for the entire national organization and for all the branches. It's if they can, that's how they act, it must be how they all act. So be careful and be cognizant of when you're speaking and how you act in the public, because that presents the image of the entire organization. There's been, what you say will come back because everything gets recorded. There was a previous webinar that someone complained that the information that they were using in the webinar got out. And this is an AALAS story at this point, but I'm sorry about that. But I expect everything in this presentation will be distributed and used by other people, whether it's proper under the policies or not. I know that everything I say and talk about here is acceptable to be disclosed to other people. Several leadership suggestions from a practical perspective here. This is from my Ducks Unlimited leadership, but also some things that came up at the board meeting last week. President Laura has, throughout her term, has been trying to establish better relations and more closer relations with the branches. And she's directed her district trustees and alternate trustees and other board members to continually to reach out to the branches in their areas for better relationship. And I would hopefully suggest to you as the branch leaders that you do likewise. Reach out to the national trustees and staff to try to form better relationships and more open communication between the organizations. We're all in this together. We have similar management, similar missions, and it will be for the benefit, the closer we operate, it will be for the benefit of all of us. From a practical perspective, and this is coming from my DU leadership days, is one of the first things you want to do as a branch leader is to find who's going to replace you. You're a branch leader for a certain period of time, and you have lots of other things, but you need to find and groom future branch leadership, people who can take over and continue the success of your branch when you leave. Also, I would strongly advise that give branch leaders and volunteers responsibilities. Don't try to do everything yourself. You're active, intelligent, hardworking people, all of you, to be volunteers in this organization and at your branch level. No one wants to come to a meeting and hear the leader or area chairman of a Ducks Unlimited committee tell them all the things he's done, and they have no responsibility other than to sit there and listen to that person. So please give your assigned duties to other people. Sometimes they'll get it done and sometimes they won't, but you're going to involve people to a greater level so they move forward and become future leaders. And I would also advise you to network with other branch leaders to find out how they do things and get suggestions. Let's talk about corporate status for a second. As I understand, all branches are incorporated. That you are not all 501c3s, but you're all incorporated. Being in a corporation or incorporated in a state brings about several annual reporting requirements that you have to undertake, at least in the state where you're incorporated, and possibly in other states where the branch has business or does activities. Some of these states, if you're a 501c3 nonprofit, maybe require you to include the Form 990 in your state filing. You should be aware of this. I know you have to file in at least the state where you are incorporated. You need to look at your bylaws. All corporations have to have a board of directors meeting at some point annually, usually. Your bylaws will list your board meeting requirements, what a quorum is, how much notice do you have to give, what are voting standards, do you need a simple majority, do you need 2/3, do you need 3/4? Can you do it by phone? Can you do it online? Does everyone have to come to a single place? So you need to look at your bylaws of your branch to determine if there's any special board meeting requirements. Materials for discussion and decision, proposed resolutions, should be provided to all board members prior to the meeting in a timely manner. Give people a chance to review what they're going to be asked to approve and think about and discuss. That goes back to your duty of care we talked about at the beginning. And minutes of the board meeting should be taken and as a corporate record permanently retained. Now, you have several styles of minutes that you can take. When I took over the minutes at Ducks, doing the minutes for Ducks Unlimited, they were almost a verbatim composition of what occurred at a board meeting, including so-and-so laughed at so-and-so's joke. When I worked for Leaf Candy previously, their board meeting minutes were the equivalent of the board convened at 8 o'clock in the morning. These people were present. These are the 5 resolutions that were passed, and the board adjourned at 3 o'clock in the afternoon. You could do this all in 1 or 2 pages. I have to recommend the Leaf method. The less detail you incur, I think, is a better position from a legal perspective. You can record your board meetings, but when you take your minutes from those recordings, I would clearly summarize what occurred briefly so that people have an understanding in the future when they look at them. And once the board minutes have been approved by the board at your next meeting or online, however they are done, then destroy the recording. You do not need to keep the recording if the minutes are the official record of the board meeting. We'll talk about IRS 501c3 nonprofit status now for a little bit. To be a 501c3 organization, the organization must be organized and operated exclusively for one of the stated exempt purposes in Section 501c3 of the IRS Code. Most of the branches, I would assume, are 501c3 organizations that their qualifications are as educational or as scientific. Some of the restrictions on a 501c3 nonprofit is none of its earnings may inure to the private shareholder or to an individual. Now, that doesn't mean you can't give grants and pay salaries, etc., etc. It means that you don't give stock dividends as equivalent. The money at the end of the year doesn't get divided among your leadership. There are also restrictions on the type of lobbying you can do. A 501c3 may not attempt to influence legislation as a substantial part of its activities. And there's been a lot of litigation and question of what a substantial part is. And right now, it seems to be defined as about 12 to 13% of the income and time of an organization. If you cross more than 12 or 13%, you are deemed to be doing the substantial part of your activities is lobbying. And the other thing is you may not participate at all in campaign activities for or against a political candidate. This is especially important in the year of the national election. A nonprofit cannot get involved in politics for a political candidate. So you need to be careful. You can support anyone you want as an individual, but you probably need to be careful not to wear your AALAS shirt or hat when you're out campaigning for a candidate. It may be an issue if you invite a presidential candidate to come speak to your organization at a meeting or anyone else running for office without extending that invitation to others that are running against that person. So you need to be aware of these, because if you do this, you can lose your 501c3 status. And if you lose your 501c3 status, your income becomes taxable, and donations to you are no longer a charitable deduction given for the person who gives those donations. When you become a 501c3, you must annually file a Form 990 with the IRS. The Form 990 is an attempt, and this is almost a quote from the IRS, is their attempt to influence the management of nonprofits to make sure they conduct their business in a way that is consistent with their public responsibilities. The Form 990 is not a tax form. It is an information form that requires much greater information about your organization, and it is available to the public. We'll talk about that a little more in a second. There are 3 different 990 forms which you can file. My recommendation up front is to file the easiest one, the shortest one. A branch with $200,000 or more in gross receipts or total assets of $500,000 must file the long form 990. And this is when they say long form, they are being truthful. A branch with gross receipts under $200,000 and total assets below $500,000 may file either the 990EZ or the Form 990. A branch with $50,000 or less in gross income can submit the Form 990N. They can also probably submit the Form 990EZ or the full Form 990. But my recommendation is always file the form that's easiest for you. Here's a picture of it. I'll point out a couple things. If you look in the upper left-hand corner under the upper right-hand corner, under the 2015, it says open to public inspection. So remember that anything you put in this form will go out to the general public. Also, it says right in the center, under the return of the organization exempt from income taxes, do not enter Social Security numbers on this form, as it may be made public. Those are a couple important things to remember. When do you file the 990? Well, it's based on your fiscal year. If you have a calendar year, it must be filed regardless of your fiscal year. It must be filed by the 15th day of the 5th month after the end of your organization's tax year. So if you're on a calendar year basis, that's May 15th. You can get extensions on the filing. The first 3-month extension is automatically granted upon request. Further extensions have to be justified. How to file it? You have your choice. You can mail it or electronically in most instances. You have to file electronically if your branch files 250 more returns, which are W-2s, 1099s, 941s, and has assets of $10 million or more. If not, you have a choice of mail or electronically. The 990N, the simple one, for the organizations under 50,000, has to be filed electronically. Your failure to file for 3 consecutive years will result in the automatic revocation of your branch 501c3 status. And there's also a note here that 3 years starts when you decide there's an intent to become a 501c3. I don't know if there's anyone, a branch out there that's not a 501c3 at this point would think it would be best in their interest to become one, but you have an issue if that's the case. Now, what does the 990 do? Well, it collects information about the mission, the programs, activities, and finances of a tax-exempt organization. And there's one thing you need to realize. The 990 can be used as a marketing tool for your branch. I had numerous discussions at Ducks Unlimited with our finance department about how they should pump up some of the information in the 990. Because when people look at it, so they can say, boy, this organization's doing a real good job. As long as it's truthful, you can pump it up and use it as a marketing tool for your branch because people will see it. If you need information on staying exempt, there's an email or there's a website address on this screen with the IRS that will help you understand the 990 more. Okay, now what has to be disclosed or expressed in a 990? Well, on all the 990s, you have to disclose your organization's mission statement or its mission and a description of the branch's service accomplishments for 3 largest programs and services. And this is where your marketing opportunity comes in. Brag about yourself. Pump it up. Let people know what a great job your organization's doing. If you filed the long 990, you also have to provide some further information and disclose whether your governing body, your board, has reviewed the 990 prior to filing and how they did it. You have to disclose whether your organization has a written conflict of interest policy and how it's enforced. You have to disclose whether your organization has a written whistleblower policy and whether your organization has a written document retention or destruction policy. And the question is, why do we have to disclose all this stuff? It's putting checks in for the IRS to make nonprofits operate more clearly, so people can trust that when their money goes to a nonprofit, it's going where it's supposed to go. You need to have available for copying and public inspection, your 3 most recent 990 filings. Someone can come into your contact your branch leader and say, I want to see the last 3 years of your 990s, and you have to make them available. Also, the IRS has them available online, and there are a number of private websites that also publish all Form 990s for nonprofits, or many 990s, because there's a million. I believe the total number of nonprofits now is a little over 1 million. You should remember one thing: if you have a Schedule B, a schedule of contributors, that does not have to be made public. So make sure when you let someone see your 990 to remove the Schedule B of schedule of contributors. The 990, I said this again, but you need to be real cognizant of this, is open to the public. So don't put Social Security numbers of anyone in there. If you're listing addresses, my recommendation, whenever possible, use a business address as opposed to a personal address, and you understand for security reasons why we need to do that. And don't include Schedule B or Schedule of Contributors. Now let's talk about the mission statement. Each organization should have a mission statement, and the question is why? Well, its answer: it sets the direction, roadmap, and parameters for what you're going to do as a branch. It needs to be consistent with the purposes stated in your articles of incorporation and your IRS nonprofit status. So if Ducks Unlimited's mission statement was to preserve habitat for wetlands and waterfowl, if we went out and started building low-income housing, we're not consistent with what gave us a 501c3 status, and that could get us in trouble with the IRS because we're not operating as we're supposed to. So you need to make sure that your mission statements, and they usually are, consistent with your articles of incorporation and what you told the IRS when you applied for your nonprofit status. Also, the branch should only undertake activities consistent with its mission statement. You should only operate within that mission statement. Ducks Unlimited's mission statement, as I said, was waterfowl, undertaking habitat restoration for the benefit of waterfowl and waterfowl habitat. There was always, as large as Ducks Unlimited was, there was always a push for Ducks Unlimited to get involved in other activities, whether it was gun control or hunting seasons for different species other than waterfowl, etc., etc. And Ducks Unlimited had what was called a singleness of purpose, that they only operated within their mission statement and would not move to areas outside the mission statement. I would strongly recommend that branches should follow this also. Here's a copy of the AALAS mission statement. I would assume it's fairly similar to all the mission statements of the branches, since we're all in this together. Let's talk a little bit about insurance and risk management at this point. You need some insurance, for lack of a better statement to start this with. You need at least general liability insurance for your organization. If you do any activities, if you have any parties, if you have any receptions, if you have meetings, you need general liability insurance. General liability insurance insures a branch for liability it may incur to a third person for bodily injury, property damage, or personal injury to that third party, which arises from your branch activities. Bodily injury is physical injury to the person. Property damage is damage or injury to property. Personal injury is libel and slander. One of the great things about general liability insurance, it also provides defense costs for these claims, whether they're valid or not. So I would recommend, if someone makes a claim against the organization, your branch, you have your legal fees paid for. Also, another reason to have GL, or general liability insurance, is when you rent a facility or for a function, whether it's a dinner or a reception, many times the facility will require you to have general liability insurance at a certain level and name them as an additional insured for liability you cause them. And the question is, well, what liability, what are we worried about? Our events are very calm and nothing happens. If someone slips and falls in your event, they're likely going to sue and are injured. They're going to sue you as the branch, and they're going to sue the facility. If someone has a drink or several and causes a problem in the facility, they're going to bring a claim against the organization and the facility. If someone's driving home after drinking at a function of a branch and has an auto accident, likely they will make a claim against the branch, and the person they hit will make a claim against the branch. So that's why you need this general liability insurance, to protect the organization. Absent the insurance, the money comes out of the corporation and the legal defense comes out of the corporation, and if there's not enough funds there, there's a chance that the people will attempt to go through the corporate veil. By being incorporated, you have some protection as members and board members that claims can't be made personally against you. But if there's not sufficient assets to run the organization and protect them, there's a chance that a person injured at a branch activity could make a claim directly against you personally as a director. The second insurance that I would recommend is directors and officers liability insurance. And now we're going to go back to the first part of the presentations where we talked about duty of care and duty of loyalty. It's liability insurance designed to pay on behalf of directors and officers, and you can add others to it, for claims arising out of wrongful acts such as errors, neglect, breach of duty, or misleading statements. If the board makes a bad decision and it hurts the organization and somebody makes a claim against it, or if a director doesn't disclose a conflict of interest and someone makes a claim against the organization, while the person with the conflict of interest won't be insured, the rest of the organization and the individual directors will be. The intent is to insure innocent and loyal directors and officers in defense of claims, but not to protect a director for active or deliberate fraud. It will not provide protection for a claim arising from the following circumstances: conflict of interest, which we've previously discussed, and committing a criminal or deliberate fraudulent act. It will protect the rest of the board in these situations, but it will not protect the individual who had these two, the conflict of interest or committed a deliberate fraudulent act or a criminal act. The question I was asked once is, how much insurance should we have? My recommendation is at least $5 million of liability coverage in your general liability and your directors and officers. Somebody said, that's a lot of money. And I said, well, I have $1 million on my own house, and you are a business, and there are people who may have issues with you, and I would recommend that $5 million, $10 million or more is recommended, if possible, if you can afford it. It's not that expensive for the coverage. So I would look into at least $5 million and $10 million. The organization I used to work for had close to $50 million. An umbrella liability policy may be necessary. An umbrella coverage, just so you know what that is a policy that sits on top of your general liability and your directors and possibly your directors and officers, which tracks the same coverage as those underlying policies, but is the ability to raise your limit to one of these higher numbers. Usually a general liability coverage won't be written for more than $1 million, so you need an umbrella liability policy to move it up to $5 million to $10 million. What other insurance risks and policies should we have? Well, let's start with, if you have automobiles, you might need automobile coverage. If you have large meetings that are very expensive, meeting cancellation is a recommendation. This protects you for funds you'd have to pay out if you had to cancel your meeting because of weather or activities beyond your control. Workers' compensation may be necessary if you have a number of employees. And that number of employees varies by state. I don't know if branches have employees. I don't think they do, but if you may need that. If you have significant property, you may need property coverage. If you don't have a significant amount, you can probably just pay for any losses out of your pockets. Crime and fiduciary is another, I believe, important coverage you might want to have. It protects the organization for internal thefts by volunteers, etc. If you have travel outside of the United States to places other than Canada, you may want to look at international coverage. International coverage moves your general as a basic conglomerate of coverages of general liability, auto, property, kidnap and ransom, and has repatriation payments if you are injured in another country and it will bring you back to the U.S. Financial protection, and this again is coming from my Ducks Unlimited days. All 3,600 chapters of Ducks Unlimited fundraise to support the mission of Ducks Unlimited. They are all run by volunteers. We find on many instances the treasurer and other members of the committee may feel that they're working hard enough that they really should be compensated for some of their activities. And to prohibit that, or to at least try to restrict it as much as possible, we, Ducks Unlimited, instituted certain financial protections or requirements for committees to reduce the chance of theft or loss of funds raised by the committee. One of the things is just have a single bank account. Now, I understand some of the branches are larger than that, so that may not be a feasible thing to do. Another item you can do is to have two signatures to issue a check. If two people are signing a check, there's a larger chance that it'll be an approved chance. You should know that the two signatures shouldn't be related people, shouldn't be husband and wife, boss and employee, or sister and brother, or something like that. And the other one is if one person signs a check, and two signatures can be difficult in situations where you're 20 miles apart for your people. In that case, I would recommend that one person, if you're having one person sign a check, the other person gets the bank statements. This just helps keep an eye on where the money's going and helps to protect your funds. That concludes my presentation. Again, I want to thank you for your participation. If there's any questions, we'll deal with them now.
Thank you, Jim. We have actually received several questions, so I'm going to go ahead and read the questions that we received during the presentation. The first one asks, is there a template of the conflict of interest policy that branches could utilize?
I would suggest you just take the one that's in the PowerPoint presentation and use that. Just change the language so it fits your branch.
Okay. The next question is, for the IRS Form 990, does receipts mean any money that comes into the branch?
I'm sorry, I had to cough. Would you please repeat that?
No problem. For the IRS Form 990, do receipts mean any money that comes into the branch?
Yes, I believe so. I'm not a financial guy, I'm saying that, but I believe it is.
If your group never filed for 501 status, should you have a professional accountant or lawyer assist you the first time?
Yeah, I would recommend that, yes. Because you have several issues. One being that going back to if you haven't filed your 990 for 3 years, but the IRS is also applying that from the time the organization decides to become a 501c3. So if you're incorporated in 2012 and say, let's become a 501c3, technically the IRS is saying you have to start filing your 990 with them as soon as you mail in your at that point for that year, which doesn't personally make a whole lot of sense. And you should only have to file your 990 once you've applied, but that's how the IRS is undertaking it at this point.
Here's another question. Beyond the annual incorporation paperwork for our state, do nonprofit branches who are not 501c3 need to file federal tax forms each year?
Yes, because you're a corporation and you have to file you would have to file as anyone has to file taxes every year, and a corporation is a entity that would be required to file their annual tax forms.
Next question. AALAS and its branches together are a large group, and large groups typically leverage discounts. Is there a group liability insurance company available to branches?
Not that I know of at this point. The issue would be how I guess there wouldn't be any reason not to contact an organization and have them go directly to the branches to see if they can have some a policy for that branch, but as the structure of the organ is set up now, it couldn't be under the AALAS national branch. It would still have to be separate insurance policies for each branch. But I suppose there's always a possibility that the agent or broker that a national AALAS is using could be a person who could be contacted to see if they can write similar coverage for a branch. And I think another suggestion might be to look at the ASAE, which is the American Society of Nonprofit Executives or something, association executives, because they have some insurance plans too through their organization that can be used by an association.
The next question was, what are the fee to use the membership list? And I'll have that answer for you. It's $100 for every 1,000 names that we pull. Another question we have is, I've talked to an IRS person, and they said we would be better suited to be considered as a 501c6 and not a 501c3. What's your opinion?
I believe a 501c6, and I'm not off the top of my head, I believe that is a lobbying organization. If that's what you're doing, that may make sense, but I'm not that familiar with the 501c6, to be real honest. But I believe it's a lobbying organization, which it allows its funds to go for that purpose.
The next question is, can AALAS legal counsel review a branch's bylaws without charge to make sure that they are legally sound?
That is a question for Executive Director Ann Turner as opposed to me. If she and Laura and the board buy into it, I don't have a problem with doing it. But again, it's usually fee for services is my understanding.
Okay. Can you speak about bonding the treasurer of the local branch?
Bonding would be an expense policy where that I believe based on the value of the assets of the organization, or the cash on hand anyway, that the treasurer would have a bond of, say, $100,000 if there's $100,000 in the account, and that if the money disappears, the bond would pay for that loss. It's similar to the crime and fiduciary, and I think crime and fiduciary would probably be a better situation.
The next question comes from, and they ask, could having all officers on the board from the same institution be construed as a conflict of interest?
I don't think so, no. It depends on how as long as they're not dealing in matters that forward the mission or benefit the institution. As long as they're acting independently and moving the branch forward and what's best in the best interest of the branch, I think they're fine.
Okay.
It's just something they'd have to be aware of and be careful of in conflict of interest.
The next question is, do you have to submit retroactive 990 forms if you've missed a year?
Yes, you will have to.
And we're getting a slew of questions in. Everyone's very excited about this.
Good.
Okay. How do you deal with presentations given by the branch by speakers and legal issues around that? For example, offering the presentations on your websites, doing PowerPoint presentations.
If the presenter, and I'll use myself as an example here, if the presenter comes in and his PowerPoint has a copyright 2016 Jim Flood or 2016 some company name, then you have an issue. You may have an issue of putting his presentation up. You need to get their permission, written permission that says, yes, you can display this after the fact, or you can use it for after the fact.
If a branch was incorporated 10 years ago, but they've just now decided to file for 501c3 or status, can we do that, or does the 3 years start from when they were formed?
The language I saw in preparing for this said it starts from when you're incorporated. I would suggest contacting or looking on the web or contacting the IRS and asking them that question. I mean, if the decision is made to become a 501c3 at this time and there was no intent prior to that fact, I think you have a strong argument that you can apply now and start filing the 990s moving forward.
And the last question we have right now is, will a corporation be penalized if they never filed taxes and was a nonprofit, to your knowledge?
Well, if you're never filed taxes, you're not a unless you had a 501c3 designation. That's how you become a nonprofit. The fact that you incorporate in the state, there may be different types of incorporation. You could incorporate as a nonprofit in some states, but as a business corporation. But I think you have potential liability there. Yes, I mean, as an individual, if you're supposed to file taxes every year, whether you have income or not, there are still penalties that could be charged against you.
Another question has just come in regarding taking photos of members at meetings. Do we have to get their permission if we wanted to post them on the branch website? And if we put a disclaimer on the membership application that states that we will be taking photos, would that cover us?
It helps. I honestly don't know that answer. I mean, I think it's best that permission be granted, but if it's clearly stated that if you come to this meeting, there will be photographs taken and they will be published on the website, and clear disclosure, I think it also goes to the person understanding the situation they're in. I think the issue of photographs showing up is when there's not an awareness that photography will occur at the event.
Okay. Well, those are all the questions we have at this time. We've reached the end of the webinar. I hope you've all enjoyed this presentation, and thank you so much for attending. Jim, thank you again for your outstanding presentation, and everyone, thank you for participating. Goodbye, and enjoy the rest of your day.